Good afternoon. Today I'm Shivani again. Today we'll be talking about the concept of regular bail and its draft under section 439 pertaining to High Court. Okay, how to draft a regular bail when you file an application in the High Court. So we'll be dealing with section 439 only mainly, and after that we'll be dealing with certain conditions of grant of regular bail, grant of bail in non-bailable cases, and so on and so forth. So let me share my screen with you. Am I audible to you guys?
Yes, you are.
Yes, ma'am.
All
Yes,
right.
ma'am, you're audible.
Thank you. Let me just share my screen. Okay, is my screen visible to you guys?
Yes, it is.
Okay, so we're going to start with the concept of regular bail and its draft under section 439. So, what are the topics that we'll be covering? First is what is regular bail, then sections pertaining to regular bail, that is special power of High Court or Court of Session regarding bail under section 439. 439 is what I'm going to be covering today because I'll be sharing the draft of this also with you. Then conditions for bail in bailable and non-bailable offences, cancellation of bail, cases related to regular bail, two of landmark cases related to regular bail, and then a draft of regular bail under section 439 pertaining to High Court. Now, what is regular bail? So, bail talks about the provisions of release of an accused in a criminal case where the trial is pending. Therefore, the court is yet to pronounce a judgment. Now, the primary objective of the arrest is to make sure that the accused during a criminal case appears before the court for the conveyance of justice. Whenever a person is arrested, he is produced before the court, and in such a case, the primary object of such an arrest is so that he appears in all of the trials that is conducted. However, to bring him to the trial while being jailed, especially when he is just an accused and not convicted, it might be unfair and unjust to violate his personal liberty. So, bail is granted as a conditional liberty to the accused. Bail, now certain cases there are bail which is granted, like it is the right of the person accused in certain cases where he will be granted bail, and in certain cases he will not be granted bail. And even in cases of the offenses that such as non-bailable offenses, it is upon the discretion of the court whether to grant him a bail or not. Now, through the provisions of regular bail, the court orders the release of a person who is under arrest from police custody after paying the required amount as bail money. Bail money is usually 10 to 20% of the furnished amount that he is supposed to pay, and post the release, there will certain condition upon based upon certain conditions he is required to pay the rest of the amount as in when required by the court of law. Now, the accused can apply for a regular bail under section 437, where he is accused of a non-bailable offense, and 439, where this Court of Session and High Court have special powers regarding the bail. Now, the idea of bail is a noble idea in criminal jurisprudence, and bail is granted to the accused in cases of non-bailable offenses subject to certain limitations and conditions. The idea of the bail conveys that the accused cannot be presumed guilty unless his guilt is proved. So, presumption of law is such that a person is innocent until proven guilty. For this statement, we have the provision of bail. Now, the provisions are incorporated with a view to give effect to personal liberty mentioned in Indian Constitution under Article 21. Now, Section 439, which is the special power of High Court or the Court of Session regarding bail. A High Court or the Court of Session may direct that any person accused of any offence and in custody be released on bail, and if the offence is of the nature as specified under subsection 3 of section 437, may impose any condition which it considers necessary for the purposes mentioned in that subsection. This subsection mainly talks about non-bailable offences pertaining to the release of bail, right? That any condition imposed by a magistrate when releasing any person on bail be set aside or modified, provided that the High Court or the Court of Session shall, before granting the bail to a person who is accused of an offence which is triable exclusively by the Court of Session, or which, not so triable, is punishable with imprisonment for life, give notice of the application for bail to the public prosecutor unless it is, for reasons to be recorded in writing, of opinion that it is not practicable to give such notice. Now, the court of session or the high court have special powers. What are these special powers? They can set aside the order or modify the order by the magistrate, which, upon condition that the high court or the court of session, before granting bail to the person who is accused, he shall be if the punishment that is given to him is not triable, or not triable for a punishment which is imprisonment for life. And even in such a case, the notice of the bail application is to be given to the public prosecutor, unless there is some statement which says that, or it is for reasons which is to be recorded under writing, that such notice is not to be given under public prosecutor. Provided further that the High Court or the Court of Session, before granting bail to the person who is accused of an offence triable under subsection 3 of section 376 or 376AB or 376DA, or the sections of 376DB of the Indian Penal Code, give notice of the application for bail for the public prosecutor within a period of 15 days from the date of receipt of such notice of such application. The presence of the informant in such a case is the person who will be informing about such an arrest, or any person authorized by him, shall be obligatory at the time of the hearing of the application for bail. When a bail application is presented before the court, in such a case, the informant or any person who is authorized by such an informant will be present at the time of the hearing of the bail application to the person recorded under subsection 3 of 376 or 376AB, 376DA, 376DB of IPC. The High Court or the Court of Session may direct any person who has been released on bail under this chapter be arrested and commit him to custody. Now, this talks about the cancellation of bail. Now, what are the conditions for bail in bailable offences? There are certain offences where the person has a right to be released on bail. And what conditions are those? Under section 436 of CRPC, it is stated that a person who is accused of any bailable offense under IPC can be released on bail. Bail is a right, and the right given under section 436 is to be utilized thoroughly by the accused in such a case. Bailable offences under IPC include, what are the offences? First is unlawful assembly, like section 144. Then payment of bribe during elections, falsification of false evidence, sale of poisonous food or drink knowingly, participating in riots, being armed with deadly weapons, furnishing false information, threat of injury to a public servant, selling adulterated drug, selling obscene books, cause of death by negligence, section 304A, stalking, criminal defamation, etc. These are all bailable offences. Now, in any of the above mentioned offences, a person can hire a bail or anticipatory bail lawyer in India to apply for bail. In our case, in this case, we would be hiring a person who would be dealing in regular bail. However, there are certain conditions on which the bail can be granted in the case a person is arrested or is likely to be arrested, which is in present case is to be arrested. There are sufficient reasons to believe that the accused has not committed an offense. This is one of the conditions where regular bail can be granted. And if the court thinks that there is sufficient reason to conduct further inquiry in the matter, if the person not accused of any crime for which the punishable offense for the offense which is punishable by death, imprisonment of life, or imprisonment up to 10 years. So in most of the cases where the punishment is less than 10 years, in such a case, the accused is released on bail, general circumstances. Now, conditions for bail in non-bailable offences. The power to release a person on non-bailable offence lies within the court, and section 437 of that talks about it. Non-bailable offence What are non examples of non-bailable offenses? Such as sedition, waging or attempting to wage war against the government, counterfeiting of Indian currency, adulteration of drug, murder, culpable homicide not amounting to murder, dowry death, abatement of suicide, abduction, trafficking of a person, cruelty by husband or his relatives, so on and so forth. Then, what are the conditions on which the court may grant bail in cases of non-bailable offenses? Now, in cases of non-bailable offenses, it is the right of it is the discretion of the court to grant a bail. In case of bailable offenses, it is the right of the accused to seek bail, and the court has to grant bail in case of bailable offenses. Whereas in the cases of non-bailable offenses, there are various factors which the court has to take into consideration, which based upon which it is a discretion of the court on which it may be granted. Now, if the accused is a woman or a child, bail can be granted in cases of a non-bailable offense. If there is lack of adequate evidence, if the court can grant bail in non-bailable offense on discretion, if there is a delay in registering FIR by the complainant, if the person accused is physically or gravely sick, like in the present case, if the accused is suffering from COVID-19 and the accused has to seek emergency medical leave, and in such a case bail could be granted even in cases of non-bailable offenses. Now also, if there is some corroboration as to personal animosity between the accused and the complainant, even in such a case it can be granted. Now, cancellation of bail. The court has the power to cancel bail, and the power is laid down under Section 437 Clause 5 and Section 439 Clause 2 of CRPC. The court can cancel the bail granted by it and give directions for the arrest of the person in police custody. However, the court does not have the power to cancel a bail granted by a police officer. What are the cases? Now, State of Maharashtra versus Sitaram Popat in 2004. In this, the Honorable Apex Court held that there are certain guidelines for the grant of regular bail. What are these guidelines? First is the nature of the accusation and the severity of the punishment in case of conviction, and the nature of the supporting evidence. Then, a reasonable apprehension. What is the apprehension? That the person accused will not tamper the witness, or tampering of witness, or apprehension of threat to the complainant, or tampering with any other evidences. Then prima facie satisfaction of the court in support of the charge. Then second case is Gulcharan Singh versus State Delhi Administration 1978. It was held that while granting bail, which are both common in the case of section 437 and 439, it is stated that the nature and gravity of the circumstances in which the offense is committed, the position and the status of the accused with reference to the victim and the witnesses, the likelihood of the accused fleeing from justice, repeating of the offense, jeopardizing his own life, being faced by the grim prospect of possible conviction in the case, tampering with witnesses, the history of the cases as well as of its investigation, other relevant grounds in view which were variable factors which cannot be exhaustively set out. So some of these factors are taken into consideration, and none of these factors are exhaustive, which means it depends on each and every case whether the bail is to be granted or not, especially in cases of non-bailable offenses, and even the cancellation of bail depends on various other factors. Now, what else can we state? At the stage of consideration of the court, what the court is normally required to consider is, then you can note this down if you want to, such as the nature, and like I've already mentioned, the nature and seriousness of the offenses. In apart from all these things, other things such as larger interest of the people or the state, or possibility of the accused repeating such a crime again, if whether he's a habitual offender or not, whether he was previously convicted in certain matters, how many cases are pending against him, or how many antecedents does the accused have. All of this is taken into consideration. The chances that the accused might flee, so this is also considered. Also, a new section, which was section 436A, was added through a writ petition of 310 of 2005. In this, the Honorable Apex Court had laid down that if the person who has, it was mainly for under trial prisoners. Now, the issue was that before the trial even starts, the accused person is kept into jail for a very, very long period of time. And to tackle this issue, it was mentioned that a person who has undergone detention for a period extending half of the maximum detention for a period of imprisonment imposed for a particular offense shall be released on his or her personal bond with or without sureties on bail. So, for instance, if the offense is more than 10 years and it is a non bailable offense, or even assuming that the offense is of 10 years and it's a bailable offense, if the person has already completed 5 years of that without being in trial, as an under trial prisoner, he shall be released on bail with his or her personal bond and with or without sureties. Now, I'll share with you the draft of the bail application under Section 439 in the High Court. Is my screen visible to you? The High Court of Gujarat at Ahmedabad District Kutch draft of regular bail. Is it visible?
Yes, now it is.
Okay, all right. So this is how the draft of a regular bail in High Court under Section 439 looks like, an application under Section 439. Here we are talking about in the High Court of Gujarat at Ahmedabad District Kutch, which means the offense took place in the District Kutch. Criminal miscellaneous application number so and so of 2021, 22, whatever it would be. Name of the person, first would be the name of the applicant, who would be the original accused. Then the age, the gender, the religion, occupation, where they reside, etc., etc. And in the present case, in judicial custody at so and so jail and arrested on so and so date, versus the state of Gujarat. Now, every criminal case is committed against the state, and therefore we write the state of Gujarat to be served through APP Gujarat High Court, and so and so would be the respondent over here. Now, an application under Section 439 for regular bail in connection with so and so ICR number of so and so at so and so place for the offenses punishable under 363, 366, 406, 420, 120B of IPC. Then we move on to the paragraph. First is, by the way of this application under Section 439 of CRPC, the applicant prays before this honorable court to grant him regular bail or grant her regular bail in connection with CR number so and so, dated with, registered with so and so police station at so and so place for the alleged offences punishable under whichever offences this person is arrested under. Now the copy of, and then we add annexure A, which is the copy of the said FIR and its addendum are annexed here and marked as annexure A column to this application. Then after we mark that, then we come on to the story of the prosecution, which is the fact of the case, which is in paragraph number 2. The story of the prosecution in brief, what is the story? That it is alleged in the FIR that on so and so date the complainant was at his house, and when at his house when the daughter was home. Later, the complainant went out of the house, the victim went out somewhere else and has been missing since then. Hence, the complainant came to be registered under section so and so place, so and so of IPC. Then the applicant states and submits before the court that this is an application preferred for regular bail under so and so, so and so. They had filed an application before the additional sessions judge in so and so place with an application number so and the same came to be rejected with an order dated so and so. Then the copy of the order is to be attached with this statement, which I have mentioned over here. Then, being aggrieved and dissatisfied with the order of the so and so person, so and so judge, uh, rejecting the bail application. So now, because the bail application was rejected, and therefore we have come in front of the Honorable High Court to seek which prefers this application for regular bail on the following amongst other grounds. Now, what are the grounds on which you are seeking an application? Seeking an application for bail? These are the present grounds. First is we write that these are general grounds, which is the applicant is a citizen of India and she is not connected directly or indirectly to the alleged offence, and she is an innocent person, has been wrongfully implicated in the offence. This is a general ground which is present in almost every application. Then the name of the present applicant is nowhere mentioned in the FIR. If in the FIR the name of the application as an accused is not present, then you write this statement that the name of the present application is nowhere mentioned in the FIR, and hence she has no direct or indirect involvement in the offences mentioned in the FIR. Sometimes, even after the person is not a person's name is not mentioned in the name of the accused or the few accused, so the person is taken into judicial custody or the police custody, as the case may be. Like in the present case, it was in judicial custody. Then you mention this ground, whatever the other ground why you need to uh, by your filing this application, that the incident took place on so and so date and no complaint was filed for the same. The FIR is filed 3 days after the alleged incident, and hence there is no explanation about the FIR being registered by registered late by 3 days. It prima facie appears that during the period of 3 days, the complainant made an exaggerated version and tried to implicate the applicant in a serious offense. That the impugned FIR does not have any basis at all. The applicant is wrongly implicated in the offense never committed by her, and hence it is her right to approach this honorable court for release of regular bail. That the victim herself went out of the house voluntarily and there is no involvement of the present applicant in the same, and hence the allegation of the applicant kidnapping the victim is completely false and baseless. That the present applicant is falsely implicated in the alleged offences of the FIR and is nowhere connected with the offences mentioned in the alleged commission of offences mentioned in FIR, and requires to be released on bail in the interest of justice. That the FIR itself is not maintainable. You write why the FIR is not maintainable, because the arrest of the applicant has been done in connection with impugned FIR only on the basis of reasonable doubt. Now, to convict a person, the court has to prove the guilt of the accused beyond reasonable doubt. So, this is a point that you can add, that the arrest of the applicant has been done in connection with the impugned FIR only on the basis of reasonable doubt. Therefore, the applicant requires to be released on regular bail in the interest of justice. That the impugned FIR, you point out uh, the loopholes in the FIR, in which you mention that the impugned FIR is filed with no substantial proof of anything, and there is no prima facie case against the applicant, and hence the alleged FIR is nothing but an afterthought, and hence the applicant requires to be released on regular bail in the interest of justice. That the alleged FIR, in the alleged FIR, offences mentioned are absolutely groundless and have no basis whatsoever in order to attract such an alleged FIR, and therefore the applicant release to be requires to be released. There are no criminal antecedents. If the person that you are defending does not have any criminal antecedents against him or her, you mention that as a ground, that the person, so and so accused person, does not have, the present applicant or the original accused does not have any criminal antecedents against him or her other than this offense registered against her. That looking to the pendency of the cases before the lower judiciary, the trial of the case would take a very long time to complete, and therefore the chances of pre-trial conviction of the applicant, therefore the applicant may be released on regular bail upon any suitable conditions that the court may impose. Then, after the grounds are stated, you again mention that the applicant undertakes to abide by, these are the same details that you will have, which will be same in almost every bail draft, that the applicant further undertakes to abide by all the terms and conditions that may be imposed while granting the bail to him or her. The present applicant takes that shall remain present on all the adjournments before the court of law till the completion of the trial. The present applicant has not filed any other application before this honorable court or before the honorable Supreme Court of India or before any other court on the subject matter of this particular application. Then the applicant craves to leave, amend, alter, delete, or modify any of the foregoing grounds as and when necessary. And the wakalatnama is duly signed, and then you finally ask for the prayer. What prayer you want? That is to allow your lordships please to admit and allow the present application by releasing the present applicant on regular bail in connection with CR number, that is with the whatever it is, on whatever date registered with so and so police station, that your lordship may kindly dispense with the filing of the affidavit as the applicants are in jail, that the lordship may grant any other further relief as deemed and just in the proper interest of justice. So this is what you ask in your prayer, and then this is what you mention, and these are the grounds that you present before the court. The grounds after paragraph number 4, you write down what are the grounds on which the person is to be released on bail, and then you finally the paragraph number 5, 6, 7, these 8 and 9, these are almost the same in almost every single draft. So you obviously you change that depending upon whatever it is, but most of the time these are the so these paragraphs are same, only the facts are different, the grounds depending upon the facts of the case, and then the initial first two paragraphs that I stated, that also remains almost the same, where they mentioned whatever, where the applicant is, you write where the person was arrested and which court had rejected the bail, and in front of which court you are appearing for the regular bail, and then you annex those copies to the application mentioned herein. So this is what regular bail was. Any questions?
Ma'am, I have one question regarding these applications. The question is, in this application, we have discussed about impugn FIR and other grounds for bail. So, do we need to discuss regarding that why lower court dismissed the bail application?
Sorry, can you repeat the last part again? Do we need to discuss?
Do you need to discuss why that lower court has dismissed the bail application?
No. See, it depends. Like if you are stating that the lower court has dismissed the so and so application on so and so ground, that is also fine. But in this particular application, we have not mentioned the reasons for that, because there are chances that the court may get prejudiced with that. So in such a case, we usually refrain from mentioning why the lower court had rejected the bail application initially, and so we go on that the lower court was pleased to reject the bail application, and thus we are filing so and so in the high court for so and so reasons, and or we write down certain sections like the lower court has failed to appreciate that this is the actual situation and this is how it is supposed to be, and this is what actually happened, while the lower court has not taken into consideration these factors. What I mentioned is a very basic draft, but you can obviously amend, alter, change based on whatever the other drafts are. Whatever the situation is, facts of it pertaining to the facts of the case. Was that clear?
Yes, ma'am. Thank you so much.
Sure. Any other questions?
No, ma'am.
All right. So, if you guys have any questions after going through the presentation, the PPT, or which will be shared with you guys, or the draft of the regular bill that I've mentioned under 439. If you have any other questions, you can drop the message in the group itself, or this video, the link of the video would be uploaded on YouTube, so you can obviously reach out whatever way is suitable to you guys. Right? All
Yeah,
right.
ma'am. Thank you.
Thank you, ma'am.
Sure, sure.
Thank you, ma'am.